Hello, I'm Doug Schmidt, and the purpose of this video is to help you to prepare for your upcoming deposition. Obviously, the first question is, what is a deposition? The answer is that a deposition is an important part of your lawsuit. It's like a mini hearing as a part of your lawsuit with the defense lawyer present, your lawyer present, a court reporter present, but no judge. The court where you will be sworn to tell the truth, the whole truth, and nothing but the truth, just the same as if you were a witness or testifying in a court of law. The court reporter will take down every word you say, word by word, and type it up later in a booklet called the deposition transcript. That transcript can be used for various purposes during the rest of your lawsuit, and we will talk about that in just a minute. As I've indicated to you, there will be no judge present, and so I will be able to make objections to the opposing attorney's questions, but there will be no judge to rule on those objections, and you will be required to answer even what I think is an objectionable question. What will be asked during the course of your deposition? Well, be prepared to have your entire life history questioned. Be prepared to ask about every treatment and visit that you've had from a doctor, your tax returns, your entire employment record. It will not be fun. There will be times during the deposition that you'll question, why on earth does he or she need to know this, and why am I being required to answer this? But the answer to that is that almost everything is fair game in a deposition. This is a very, very important part of your lawsuit, which leads us to the next question that I avoided just a little bit ago. How will this deposition be used? Well, there are a number of ways that depositions are used. First of all, the defense lawyer will learn about your case, learn as much as he or she can learn about the case in order to avoid surprise on their part. And for that reason, the more you volunteer, the more you're helping them. And we'll talk about how important it is not to volunteer in just a minute. Secondly, they'll try to learn as much about your case as they can to prepare a defense. So again, the more you tell them, the more they will be prepared, be able to prepare a defense, collect the evidence that can be used against you, and present a better defense. Again, the more you volunteer, the more you talk. Or in another way of putting it, the more you blab away, the more you're helping the defense. Thirdly, they want to pin you down so that if you say, and get you to say as much as you can, so if at trial you say something else, they can use it to what's called impeach the credibility of your testimony and make the jury perhaps believe that you're not very good at telling the truth. So it's important that you give the truth, the whole truth, and nothing but the truth, and you give them as little as you can, that you don't volunteer extra information to help them out. Finally, and probably the most important to you, is that the deposition is a time for the defense lawyer to evaluate you as a person, how strong your case is, how good a witness you will make, and how you will or will not impress the jury at your trial. And in this respect, it is, you will not win this proceeding, you will not win a deposition, you're not going to be able to convince the defense lawyer of your case. You will win the deposition by convincing him that you are a good witness, you know how to answer the questions, you don't fly off the handle, that you look like a credible, likable human being. So you want to be polite and well-mannered throughout the course of the deposition. It's very helpful that it be a yes sir, no sir, or a yes ma'am, no ma'am. If you don't understand the question, you say, I'm sorry, could you help me out here? I don't understand the question. Be polite, keep your cool, don't lose your temper, and you will make a better witness, you'll make a better presentation to the defense lawyer, and it will increase the settlement value of your case. Remember this. When I talk in this video about increasing the value of your case or about impressing the jury, our ultimate goal is not to go to trial. Our ultimate goal in your lawsuit is to get a settlement of your case for a fair figure, for the best possible figure. But the only way that we do that is by convincing the defense that if they don't pay a reasonable sum, they don't pay a higher amount, that and if the case has to go to trial, that we'll do a good job, that you'll be a good witness, and the jury will be impressed. So when we evaluate how this is going to impress the jury, it's for settlement purpose, to increase the settlement of your case, and not because we really want to go to trial. So with that, let's move on to the details of what you need to know about your deposition. What I am about to tell you comes as a big surprise to most of my clients. And it's this. You are about to enter the world of lawyer talk, or some people say lawyer speak. And lawyers speak differently. And you're expected to speak differently in a court of law than you do in everyday speech. This may be the only time in your entire life that you're expected to speak in the way of lawyer talk or lawyer speak. And the best way that I can explain it to you is to give you an example. When I was practicing law outstate, I was invited to a party with some faculty members from the local junior college. And I found myself standing with a group of men. That was in the days where the women were on one side and the men on the other. And I realized that the person to my right was somebody that I hadn't met before. And I turned and stuck out my hand to shake, and I said, "Hi, I'm Doug Schmidt. I didn't catch your name." And the answer came back, "I didn't give it." And I kind of gulped, and I said, "Why? Can you tell me your name?" And he said, "Yes," and stopped. And I said, "Okay, so what is your name?" And he says, "Victor, Gene Victor." I said, "What do you do, Gene?" He said, "Lots of things." I go, "Okay, try this, Gene. What do you do for a living?" "I teach." "Well, what do you teach, Gene?" "Students." And I go, "Okay, so what subject matter do you teach to those students, Gene?" And he said, "Philosophy." And I said, "You know, Gene, if your classrooms are anything like this conversation, you don't teach poop. They learn on their own." That was a completely antisocial conversation. Perhaps the most antisocial conversation in my entire life. But the message there was that it was the perfect way that people are expected, that I expect my clients to answer questions during a deposition. Think about the questions that I had to put to Mr. Victor to get to the answer. He didn't volunteer anything. He gave a specific answer to every question. I didn't catch your name. I wouldn't answer that at all in a deposition. There was no question there. Well, made me ask again, what is your name? Victor, Gene Victor. Didn't give any extra language or any extra evidence. What do you teach? Or what do you do? Lots of things. What do you do for a living? I will expect you, to the extent that you possibly can, to require the defense lawyer to make his or her questions as specific as Mr. Fichter, a non-lawyer, Professor Fichter, was making me ask those questions. He didn't volunteer anything, but he did give a specific answer to every question. So that's point number one. Concentrate on talking in lawyer speak. My recommendation number two is stay in control. Now, most people think that when they go into a deposition and the defense lawyer gets to ask them questions about their entire life, about their childhood, about their tax returns, that lawyer is completely in control. They feel that they are subjugated to what that lawyer is doing in the questioning process. And my answer to that is not true at all. You do not need to answer questions fast because the lawyer is shooting them to you fast. If the lawyer wants to shoot questions fast, take your time, count to 10, and answer it when you're good and well ready. Stay in control. Next point, do not answer a question that you don't understand. You have every right to say, I don't understand your question, but do it politely. Impress the defense lawyer with the fact that you're going to look like a nice, polite person if this case should ever go to trial. Sir or ma'am, I'm sorry, I'm sorry, I just don't understand your question. Could you rephrase it? And third point. The third point is every question and answer involves a thinking process, a slow process of, I say, sometimes a 4-point step. Number one, listen to the question. Number two, think about the question. Think back to Professor Fichter. He was not giving a knee-jerk answer. He was thinking, what do you do? I didn't ask him, what do you do for a living? And so he gave an appropriate answer. I do lots of things. What do you mean? And again, that would be antisocial, talking to your friends or neighbors. Third part is think about your answer. Construct the answer in your mind. And then step number 4, very carefully and deliberately give the answer. If you are not going through that 4-point process, you're going to fly off the handle and give answers to many times to questions that you're not quite sure that you understood, and without thinking about it. We're about to roll up our sleeves and get into the hard work, the details of the instructions or the recommendations that I have for you regarding your deposition. But I want to stop here, and I want to refresh what we have discussed so far. Number 1, we're talking lawyer talk now. Number 2, stay in control. Number 3, slow it down and make it a thinking 4-step process. Think about the question, or listen to the question, number 1. Number 2, think about the question. Number 3, think about the answer. Number 4, deliberately and carefully give the answer. And that's going to take us then to the 4th recommendation that I have to you, and that has to do with pace. And my recommendation to you is this: take your deposition at a slow and deliberate pace. You have the right to take a break anytime you choose, anytime you ask for it. And if the defense lawyer should get chippy about it, just say you have to take a bathroom break, and there's no way that he or she is going to deny any human being a bathroom break. I have found, as a result of my years of experience in this business, that my clients do a much better job of answering the questions and doing what they need to do at a deposition for the first 30 or 45 minutes. And then they get tired. They get mentally tired. And it's hard work. And so I typically request, in fact demand, that my clients take a break at every half hour to 40 minutes. Step outside, get a breath of fresh air, clear your mind. Think about, have a moment to analyze how you've been doing. This gives you the chance to talk to the attorney, and which you can't do during the course of the deposition. Like I said, when you're up at the batter's plate, you can't talk to the coach in the dugout. So take a break every half hour to 40 minutes. This is really surprising. It's going to be surprising to you that what I am about to say, and that is, I can tell my clients to take a break every half hour to 40 minutes. They get in that deposition, they lose track of time, and so many of them will go on for an hour and a half, and they get mentally tired and they start blabbing away and losing it. So do not think for 1 minute that you are going to get this process over quicker by blabbing away and going straight on through without a break. No, 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 no. What will happen if you do that is you'll start blabbing away, you'll start volunteering extra information that opens up new question areas to the defense lawyer that would never have presented themselves to that lawyer. Folks, it's time to get down to the nitty-gritty, to the hard work, the detailed rules, and the next one is going to be perhaps the most important rule of all. And here it is. Don't volunteer. Many of my clients don't have any idea that they're volunteering information, as opposed to giving a specific answer. A simple example of that is state your name, and you give your name. Tell me where you live. And many of my clients will give the street address and the town. If I were to be answering that, I'd say 222nd Street, Excelsior, Minnesota. Well, no, I can answer that question very specifically without volunteering information by simply saying Excelsior, or Minnetonka, or Richfield. It is extremely important that you don't volunteer extra information. If they ask you what the make and model of your car is, you say, they ask make, so it would be Ford Expedition. I can't tell you how many of my clients will say, I have a 1999 or a 2008 blue Ford Expedition. They don't realize that they are adding extra information that they're volunteering information. Specific answers. If they ask you the names and ages of your children, you say, take your time, think about it, and say, Johnny, age 16, Susie, age 14, Linda, age 10, and Jamie, age 7. So many people will say, well, my oldest child is Johnny, and he's 14. And then we have Susie, my daughter, who is 12 and in the 7th grade, and are just throwing extra information in all the time. There's another thing that people do, and it's called bridging. Bridging is when, instead of answering the question, and typically most questions call for a yes or a no, or where do you live calls for Minneapolis, Minnesota, specific answer. But they bridge. And a classic example of bridging is, I remember one case, and it's in the written materials that I give to you, do you swim? And the answer came back, I have ear infections. Well, there was no yes or no to that. And what should have been the answer is, do you swim? No. Then if the defense lawyer wants to know why, he'll say, why do you not swim? Well, I don't swim, sir, because I have a recurrent chronic problem with ear infections. In that particular case, because it was a pulmonary injury, the answer to that question, do you swim, I have ear infections, opened up 2 pages of questions and answers by the defense lawyer that I think with a high degree of certainty would never have been asked if the bridging answer had not been given. Do you swim? No. I think he would have gone on to then say, well, do you play basketball, or do you run, or do you jog, or do you go to the health club? But by volunteering and by bridging without giving a specific answer, my client opened up 2 to 3 pages of questioning about which revealed that the ear infections had been a chronic thing for a long time. They'd started when he was in teenage years. He'd had a lot of medical treatment about it. Would never have, would never have been asked. Do you know how fast you were going? That's a question that can be answered with a yes or a no. Instead of saying, well, I wasn't watching my speedometer, which would be a volunteered, non-specific bridging. While we're on the subject, I need to talk to you about estimates. If it is okay for you to answer a question, do you know how fast you were going, with an estimate? In other words, you know that you were going approximately 35 miles an hour, or you know that you saw that doctor in approximately last September, but to say I don't know at all disqualifies you as a witness and makes it very difficult for you to come back later at trial or otherwise and say, well, yeah, I know that I was going approximately 35. So be sure that you have talked over with me or the attorney that will be with you at the time of your deposition the details of how the accident happened. and decide what you want to be pinned, what's important that you pin down as a part of your case about how the accident happened, and what isn't an important part. The difference between volunteering and giving specific answers is a fine line that's very hard for some people to master and to understand. Before we leave the topic of rule number 5, don't volunteer, I want to discuss it in a different light. People don't realize this, but you can volunteer in 2 different ways. With the words you use, or with your mannerisms. An example of the words that you use is, do you have headaches? Well, not like I used to. They're not as bad as they were before the accident. Wow. You answer a question that way, and there isn't a good defense lawyer known to the Lord that won't follow up by asking you a number of questions about what kind of headaches you had before the accident. Now he or she might have gotten to that point anyway. But when you're answering a question that way, you're inviting them to ask you about 3 or 4 more pages. I remember a case when some years ago when I was walking back, I was officing downtown, and I was walking back in the Skyway with my client after a 4-hour deposition. And he said, wow, that defense lawyer was terrible. He shot questions at me for 4 hours. And I turned to him and I said, Dale, it would have been 2 hours if you hadn't volunteered. Because the other 2 hours were him following up on stuff that came out of your mouth that didn't need to come out of your mouth. That was all volunteered, and you just invited it. You didn't realize what you were doing, but you invited the questions for at least 2 of the 4 hours. The second way that you can volunteer information, and this is really the hard one to overcome, is with mannerisms. It's kind of like keeping a poker face. Any of you that have played poker know that you can certainly give your opponents an idea of what's in your hand with expressions on your face. Sport coaches, baseball coaches talk about tells. A pitcher, when they're throwing a strike ball, will grip the ball a little different or hold the glove a little different than they do with a curved ball. Some football players even give a tell as to whether it's a running play or a pass play by how they put their hand down on the grass when the lineman takes his stance. Mannerisms. Did you have headaches before the accident? And if you go like this and you go, well, no. Oh my goodness. That defense lawyer is not going to let that answer stand, and is going to question you for 10 minutes, 5 or 10 minutes, before he or she is satisfied that didn't have a whole lot of evidence behind it that would help the defense. We just talked about mannerisms on your part, and now I want to talk about mannerisms on the part of the defense lawyer. I want to talk to you about the unspoken question. that is perhaps more compelling than the spoken words. Let me give you an example. If the defense lawyer says, "Tell me more about that. Tell me more about that." There's no question there. Don't bite on that trap. Your answer has to come back saying, "I would be happy to, what would you like to know?" If you're talking about your neck pain, "Tell me more about that." Don't blab and volunteer and give him a Christmas present of answers all wrapped up in a pretty bow. Say, "Tell me, I would be happy to, tell me exactly what you would like to know." But that takes us then to the silent or the unspoken question, where the defense lawyer goes, "Yes, yeah, tell me, yeah." I am telling you, I have watched hundreds of people that will be in my clients that will be in the position that you will be in at the time of your deposition, that all the defense lawyer needs to do is put their finger to the ear or give a quizzical look or gesture with their hands, and it's more compelling, more difficult for the average person to not respond than the spoken word. Before we leave the subject of volunteering, I want to talk to you about the subject of thinking out loud. And the sub-rule here is, don't think out loud. It is a corollary of the rule, don't volunteer. Let me give you an example of thinking out loud. How fast were you going is the question. Well, let's see. When I was down the road, well, the last time I looked at the speedometer, I was probably going 40, and I may have slowed down a little bit because I saw that dog in the road, and so probably going between 30 and 35. Wow. The answer to that question should have been 30 to 35. All of that thinking out loud was a gift to the defense that will help them, or may at least, we don't know for sure, but may at least help them to come up with some impeachment evidence against you that will weaken your case. We're about to go to rule number 6 about how to deal with objections by your own lawyer. But before we do, I want to just emphasize or re-emphasize a point clarify a point that I made earlier. I told you that you typically are not allowed an opportunity to talk to your lawyer during the course of the deposition. You can talk during the breaks. The rule, the technical rule, is that you are not allowed. But don't hesitate to ask for an opportunity if there's something that you want to talk to me about. Ask for an opportunity to go outside. If the defense lawyer grants it to you, all the better. Take advantage of it. He or she doesn't have to grant you that opportunity, but feel free to ask it. Don't let anything I've said here about you not having that right prevent you from asking. However, beware. Remember this. By asking to talk to your lawyer about a specific question, you are losing your poker face and you're sending the message to the defense lawyer that there's something about that question that is bothersome to you. And that will send the message to the defense lawyer, that that question is one that they need to follow up on with a whole lot more detail, because there's a buried treasure in there, maybe, for them if they do so. So that takes us to number 6, objections. My advice to you is that anytime your lawyer makes an objection, that's a signal to you. You should take it as a signal. Don't go to sleep on that. Some of my clients, when I make an objection, think, that's just the lawyer doing his thing, and this is a time when he's talking for me to relax and I don't have to be thinking about it. No, 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 no. Anytime your lawyer is making an objection, he is doing it for the record, and it may look like he's talking to the judge who may rule on that objection in a month or two, or maybe never at all, but he's really talking to you. If he says, if he objects that the question is vague and not understandable, don't answer it. That is a signal to you that there's something wrong with the question, that maybe you don't understand it. I have had a number of times when I've been in depositions where I object to the defense lawyer's question as being vague and incomprehensible, and the defense lawyer will turn to my client and say, well, do you understand it? And my client will say, yeah. Well, then it chops my objection off at the knees, totally undercuts it, and you're going to have to answer. You didn't get the message from me that that question is vague and is not understandable. Remember this. I've gone through, I bet, 2,000 depositions in my legal career. I have a lot of experience in what is a specific question and what is not. And I submit to you that defense lawyers, some of them ask bad questions simply because they don't know how to ask a good question. And many of them ask bad questions on purpose because they want to confuse you, and confuse my client, and simply see what comes out. If I make an objection that calls for speculation or guess, then the signal to you is, don't guess. I'm not talking to you. I'm looking at the court reporter when I'm making the objection, but I really am talking to you. And I'm saying, don't guess. So keep that in mind. Take objections as a signal. One of the objections that I might make, following up on that last point, is objection repetitive. Or another way that lawyers put it is objection asked and answered. That means it's been asked before and it's been answered before, and the question is objectionable. And so you might want to pick up on that. You should pick up on it by saying, I've already answered that. And stick with that. I've already answered that. Now, this takes us to number 7. Don't give up. A good defense lawyer will figure out how to virtually ask the same question over and over and over, or come at it from a different angle. And don't give up and get soft just because the question is being asked 2 or 3 or 4 times. One of the unfairnesses of a deposition is that there's not a judge there to rule on the objection, and accordingly, even though I might be objecting to a question that has been asked and answered that is repetitive, the defense lawyer has a right to, sadly, to keep asking the question 2 or 3 or 4 times. And you need to stick up for yourself by simply saying, I've answered that. I've answered that. And even if they say, no, you haven't, I think I've answered that. Point number 8 is assuming that your case is a car accident case or a motor vehicle collision case, how do you handle the issue of distances and speeds? I recommend that in most cases my clients are not the ones at fault, or I wouldn't be taking the case, and it's the defendant that is at fault. And the defense lawyer is going to try to pick at you about how far away from the other car were you. When you first saw it, how fast were you going? When you first saw it, how far back from the intersection were you? How far away from the other car were you? When you first applied your brakes, how fast were you going? How far away from the other car were you? And when you collided, when the two cars came together, how fast were you going? You should review those facts with your lawyer before going into the deposition so you're comfortable that you're giving an appropriate answer. But remember this, in most cases, it's better for you not to pin yourself down on exact distances. If you do, the defense lawyer can do, it opens the door to he or she doing math, saying, well, if you were 200 feet away, and if you were going 50 miles an hour, and if you were going only 30 miles an hour when you applied the brakes, and if you were going 20 miles an hour when the two vehicles together, that math doesn't all work at all. They start playing mathematical games and arguments in front of the jury that can provide the support for a claim that you were partially at fault in the accident. So you're better off saying, you know, I'd really have to think about that. I'd want to go out to the scene of the accident and try to reconstruct that. I'm not prepared to answer your question at this time. Be careful, though. Complete ignorance and you can't answer any question, then can be turned against you that into an argument that, gee, you must not have been paying any attention to your driving if you can't answer those questions at all, if you just don't know at all. Be careful. And I don't know can be construed as I have no idea at all. And then if you come back later and give an estimate, they'll say, how is it that you had no idea at all at the time of your deposition, and now all of a sudden you know? And I'd have to think about that. Does not pin you down. Or giving an estimate does not pin you down as much as or disqualify you, I should say, as much as an I don't know. And I'd have to think about it. I'm not prepared to answer that at this time. Those are the kind of answers that you can give that don't pin you down. Many of my clients say, well, Mr. Schmidt, why don't you just give me a list of the questions that they'll probably ask? And I could do that. It would take a long time in each case to sit down, and if I did it, I couldn't possibly anticipate every question that the defense lawyer might come up with. I see a lot of the questions that are asked in depositions to be stupid, unintelligible, irrelevant, and it would take the wildest imagination on my part to be able to anticipate all of those questions, even those that are stupid and irrelevant and impossible to anticipate. But there's a more important reason why I wouldn't want to, and it wouldn't be a good idea for me to give you a list. I could never word, the reason is I could never word the question in the way that the defense lawyer will be wording it for you at the time of the deposition. And for that reason, it's so important for you to think about the exact words, the exact way that the defense lawyer has asked the question or is asking the question in your deposition. If I were to try to anticipate that question and write it out on a piece of paper, when you hear it come out, a question that seems to sound like the same thing that Mr. Schmidt wrote out on a piece of paper, there's a danger that you might get it wrong. You might think it's the same question that Mr. Schmidt was asking, and in the same exact way that Mr. Schmidt was asking it. I raised the question previously, what will be asked of you in the deposition? And again, I've said that it's hard to anticipate. Every lawyer, a defense lawyer, has a different style. But I will tell you this, it's very, very likely that you will be asked to give an injury list. And you may also be asked to give a symptom list and a list of the activities that are affected by your injury. And you might, I suggest that before you come to your deposition, as part of the preparation, that you write out your injury list. We have likely prepared an injury list for you in the answers to interrogatories. Review those answers to interrogatories. Make sure that you know and you're prepared to give the full list. I find that a lot of times people who have had a knee injury, an ankle injury, a cut on the head, and end up with the long-term permanent neck and back injury will oftentimes forget to tell the lawyer about the injuries that they no longer experience, the injuries that have healed, the cut on the head, the ankle, the knee. I find that it is helpful for that injury list to start at the top of the head and work down all the way to the toes. Yes, I had a cut on the head. I had initial head injury with disorientation, dizziness, blurred vision, mental confusion, and headaches from my head injury. I had a neck pain radiating out into both shoulders. I had mid-back pain. I had chest pain where I went forward into the shoulder belt. And I'm saying that you wouldn't want to say that it was due to the shoulder belt. Just saying you had chest pain was enough and specific. But I'm saying that to you. Hip, low back pain, pain radiating into the hips, the legs. I had a right ankle, a left knee, a great toe injury, whatever it might be. Then they'll be asking you about the symptoms. And don't forget all of the symptoms. Pain. When we talk about pain, I don't want to hear ache. The word ache should be purged from your vocabulary. An ache is a pain. So you had pain, numbness, swelling, loss of feeling, weakness, dizziness, tingling. Those are all the things that you'd want to mention as symptoms of your injury. They'll ask you, likely ask you, what activities have been, of your daily living, have been affected. And if it's really true, and it is in most of my clients' cases, that everything in my life has been affected. If you have neck and back pain that's constant, that never goes away, even though you deal with it and go to work, even though you continue playing baseball or bowling or whatever it is you do, it still affects you. And many of my clients even have sleep interruption due to the neck and back, the shoulder, the knee pain. If that's true, a good answer is, when you're asked what activities of your life are affected by your injury, is to say, sir or ma'am, everything in my life. It throws it back to them, and now they have to ask you specific questions. And if they come back and ask you, well, what about recreational activities? If they ask you, what about your household activities? What about your work activities? What about your personal activities? then you don't have to worry that you have missed something along the way, because you started out answering the question, everything. And now that has trumped their ability to embarrass you at trial if you give a symptom that you didn't mention in your deposition. I told you at the outset this was not going to be fun, and that's right, it is not going to be fun. I told you at the outset it's an important part of your case, and that is in fact true. You will not do a perfect job. You will make mistakes. That's to be expected. This is you're not a professional witness, but I just ask that you prepare as well as you can, that you keep these rules in mind and do the best that you can. I want your case to have as good success as possible. I join you in that, and if you will follow these rules, I think that'll be helpful, and you will do as good a job as possible. Again, I say good luck to you in your deposition. Feel free to ask me any questions that you have that this video or the written materials that I send to you might raise in your mind. We're here to help you. God bless.